Hello, everyone. My name is Katie Brown,
And I'm Jessica dePerio Wittman.
and we are presenting today on who is shaping technology competency in ABA-accredited law schools.
And in case you were wondering, the answer here is law librarians.
So we all know that we are in uncertain times. We're unsure if there's going to be an ABA or if the ABA is going to be still accrediting the accrediting body for law schools, or if it's going to be accredited by the state, or maybe regional accreditors, or maybe it's going to go to the state Supreme Courts, or maybe it's going to be a completely new accreditor that no one's even seen. So because of this uncertain times, all we really can look to is, even though technology competency is vague, we only have the standards that we have from the ABA. And really, we've got to go back to that history of where it came from.
So, as Katie mentioned, the language defining competency has always been intentionally vague. Scholars have debated for years that technology competency has always been addressed. So the original rules in 1908 called canons, they start off by addressing individuals demonstrating graft, greed, gain, and other unworthy motives while holding themselves out as lawyers. And over 60 years later, we see the ABA start to address competent representation. 10 years later, in 1979, the annotated code continued to exclude a definition of competence. Then an ABA task force on lawyer competency attempted to provide a definition. In 1983, we finally see Model Rule 1.1 and 1.6, and we see that the use of the term competence is actually mentioned in 1.1. Now, the 1983 code comments address the need for attorneys to act competently to safeguard information relating to client representation against unauthorized access. But it's almost until 30 years later that the Commission on Ethics identifies some new technologies that might fall under this definition, but still doesn't provide a definition. And lastly, Comment 8 of Rule 1.1 offers lawyers guidance on understanding the benefits and risks of technology. So why should law schools care about teaching technology competence? ABA Standard 301 requires law schools to provide a rigorous program of legal education that prepares students for effective, ethical, and responsible participation in the profession, including technology competency. 303 requires that a law school provide substantial opportunities to develop a professional identity. And in our scholarship, we assert that technology competency is a part of developing a professional identity. Despite this, law schools often lack clarity and consistency in defining and delivering technology competence, creating gaps between academic preparation and real-world demands.
And according to Bloomberg Law's 2024 Law School Preparedness Survey, 62% of attorneys wish that new arrivals learned legal technology. Additionally, 70% of attorneys supported the idea of students learning generative AI as part of their legal education. So, given how central technology has become to legal practice, and with so many attorneys and employers calling for stronger tech skills in new lawyers, it's no surprise that professional standards have evolved to keep pace. So let's take a closer look at how the ABA and state bars have responded to this need through formal rules on technology competency.
First, let's look at ABA Rule 1.1. We're going to assume that everyone here has some familiarity with the basics of technology competence and the relevant rules, specifically in Rule 1.1. But Comment 8 builds on this by requiring lawyers to keep up with the benefits and risks of relevant technology, engage in ongoing education, and meet all continuing legal education requirements. And so far, 40 states have adopted some version of Comment 8. But not all states use the same language or approach. And so this means that lawyers, especially those that are practicing in multiple jurisdictions, need to pay close attention to how their state interprets and enforces technology competence, as requirements can vary significantly from jurisdiction to jurisdiction. For example, some states may accept general CLEs, while others may have specific technology-related mandates. And when read in tandem with Rule 1.1, Rule 1.6 also shapes our view of technology competence, along with formal opinions that address just-in-time issues regarding or related to technology. For example, 495 and 498 are our COVID opinions addressing remote work and the implications of virtual practice. And we also have the newly released 512, which addresses AI. While ABA Formal Opinion 512 provides crucial ethical guidance for lawyers navigating the use of generative AI, it's important to recognize that having rules and opinions is only one piece of the puzzle. Formal Opinion 512 clarifies a lawyer's obligations regarding competence, confidentiality, and supervision when using AI, but translating these standards into daily practice obviously presents its own set of challenges. Understanding the risks and benefits of AI, ensuring informed client consent, and supervising staff are all foundational. Yet the actual integration of technology into legal workflows requires more than compliance. It demands practical skills and ongoing adaptation. Now, let's explore how competency models sought to bridge the gap by defining the technology skills and capabilities that lawyers needed to thrive in a rapidly evolving legal landscape.
So many of you may be familiar with the different lawyer competency models. In the beginning, we sort of had this model that was the I shape, which was these bespoke services that were very tailored to individual clients. This moved into the T-shaped model, which really dove a little bit more into depth of knowledge and lawyering skills. Then the Delta model became very popular. And then most recently, we have the whole lawyer model, which addresses competencies and capabilities. Now, the thing that is interesting about all of these models is that they do touch on technology in some way. But most recently, with the whole lawyer model, which again is focusing on those competencies and capabilities, it really incorporates a wide variety of technology skills that are used in everyday practice. So, in our forthcoming article in the Journal of Law and Technology at the University of Texas, we actually chose to define technology competency in a legal practice as more of a holistic understanding of how to ethically and practically apply and integrate both hard and soft technology skills. So on the next slide, you'll see how our definition is best applied when using the whole lawyer competency model.
For example, if we were looking at the category of basic communication, we think about foundational lawyering skills, such as proactively providing status updates to those involved on a matter and promptly responding to inquiries and requests. For these skills, lawyers needed competencies and capabilities in email, text, and Microsoft Office. Working cooperatively and collaboratively as part of a team requires tech competency skills in intranets, extranets, Slack, Microsoft Teams, Zoom, and SharePoint. Looking at legal practice, lawyers are expected to draft contracts, agreements, pleadings, motions, and briefs. That will require lawyer competency in Microsoft Office, legal research databases that provide templates, and contract management systems. Interviewing clients and witnesses will require some type of competency in AV equipment, Slack, Microsoft Teams, and different ways to communicate with their clients, either in person or virtually. Requesting and producing written discovery requires competency in technology-assisted review, e-discovery systems, and Boolean. When we look at legal thinking and application, lawyers are expected to effectively research the law, speak in a manner that meets legal standards, and maintain core knowledge of substantive and procedural law, just to name a few. For those skills, lawyers will need technology competency in legal research databases and websites. Again, we see the Microsoft Office suite being prevalent, email and text. And lastly, under legal ethics, concluding relationships appropriately, documenting or organizing a case or matter, and keeping information confidential are all skills a lawyer needs to possess. To carry out these skills, a lawyer will also need competency in case management systems, encryption, data privacy, VPNs, information governance, and cybersecurity. And unless you've been under a rock for the past few years and looking around the room, we all know that all law librarians, whether working in academia, a firm, or at a government entity, carry these hard and soft technology skills in their bag.
So we hope we've already sort of established this, but law librarians are uniquely positioned then to bridge this sort of doctrinal theory and practical application of technology. And so therefore we are best for offering both these formal kind of credit-bearing courses and informal workshop consultations on technology training. And we are doing that right now in ABA-accredited law schools. And so what we're doing is our expertise that we already currently have, it's allowing us to stay current with evolving legal technologies and vendor tools. We are designing and delivering training that meets both ABA standards and real-world practice needs. We're collaborating across departments to embed technology skills throughout the curriculum. And we're also doing as law librarians, we're also playing key roles in supporting faculty with technology teaching and research and course design when we're asked to assist. So now let's start adding in some of our empirical data to support this assertion. When you look at our data that we started collecting in 2017 to now, with law librarian-led instruction for both for-credit courses and informal settings, we find a significant growth in the technology instruction by librarians. In particular, when we look and we compare just from 2020 to 2023, and what we did was we chose to break up the librarian instructor because we know that librarian status will change from institution to institution. So if we look at librarians as adjuncts versus librarians as with a faculty status, and then librarians in non-faculty roles, often categorized as staff. We see in 2020 when we were looking at informal instruction. So to recap, that would be more workshops or sort of lunch and learns, that kind of training. We're seeing librarians as adjuncts, 7.5% of instruction in 2020, jumping to 20% in 2023. Pretty significant here. We're seeing librarians as faculty. In 2020, we have 37%, a huge jump to 66% in 2023. And then librarians as non-faculty, 15%, and then we get that jump in 2023 to 29.5%. So now let's take a look at the growth that we see in instruction with formal instruction. So again, these are the for-credit technology or technology-related courses that librarians are providing instruction for. And so again, we've got our three categories. We're looking at librarian adjuncts, librarian as faculty, or librarian non-faculty. So we're still seeing a jump with librarians as adjunct, not as significant as we saw with the informal. So we go from 9.52 to 10%. With faculty, we've got a decent jump there from 28.57 to 49%. But this jump from librarian to non-faculty, we go from 7.14% up to 15% in 2023. One thing as I'm especially looking at this for credit instruction that I find pretty interesting is, one, it sort of supports this idea that more and more ABA accredited law schools are actually greenlighting these technology courses. But I think it also supports our assertion that librarians are the ones who are teaching these courses because we have an interest in this area and the skill set for it.
So now that we see how law librarians, or how many law librarians, are teaching technology, Let's take a closer look at the hard and soft skills expected in practice and the number of technology and technology-related courses that offer an opportunity to introduce these skills. For context, the data set that we are drawing upon for the next few slides was collected in 2023, and this data set is referenced in our upcoming JOLT article. When surveying all of the ABA-accredited schools, the sample size of our data was 310 courses. Our methodology involved having our research assistants collect course information that was readily available on the web, along with course descriptions and any available syllabi that they could find, and cross-referencing them with foundational skills that we've provided to them in a separate data set.
All right. So the other thing that we did with that data that we received was we cross-referenced that again, looking at our definitions for what hard skills and soft skills are. So here, if we start out with this proficiency with legal research databases, the foundations that we have are effectively research the law, identify relevant facts, legal issues and information gaps or discrepancies, learn and use relevant technology effectively. When we look at those practical applications, obviously we have this all of those research databases that many of us have at our law schools. So when we break down our 310 courses, we have about 139 technology related courses that are including this research and instruction within their technology course. We have 235 courses that are identifying relevant facts, and as appropriately, we do have of our 310 courses that we were able to locate, 310 courses that are talking about technology and technology related issues. Next, we're going to be looking at metadata. We know how important e-discovery is. It's becoming more and more prevalent and is one of those things that is more often than not being taught in even survey-related legal technology courses. So again, that's our example application that we've provided here. Foundations, we have keeping information confidential and requests and produce written discovery. We're finding 215 courses where we have that foundation tagged, and then 103 courses for producing and written discovery. Knowledge management and information management is our next hard skill. And this, I also want to mention here, one of the things that we chose to do for this presentation, many of these hard skills may have overlapping foundations, but because of, so that you all would be able to read the information on the slide, and just for ease of use with our discussion, we chose not to overlap foundations. So please know that some of these hard skills would have additional foundational information that maybe would be under another category as well. So we just chose to provide you with that foundational information once and not repeat it on an additional slide. So here, when we look at this knowledge management and information management, the foundations that we chose to provide you all with, we've got document or organize a case or matter, where we have 194 courses. We had gather facts through interviews and searches, where we have 242 courses. And then I wanted to highlight this because I find this really interesting, right? We know that with the practice of law, there are those sort of day-to-day functionality type things that certain practices, especially litigation type practices, they have that are, it's that drudgery work, right? But they have to do it, and timekeeping is one of those things. But here we discovered that we, at least based off of the information that our students were able to locate, there were only 60 courses that included information about timekeeping or billing procedures within their course. And when we tie that to practical applications, these were courses that had included information on case management software, as well as things like the Office suite. So hard skill of artificial intelligence, right away, when you're looking at this slide, you're probably noticing we've got a couple of asterisks here. We wanted to highlight that because if you have seen or read some of our earlier work where we talk about keying data to the foundations, you're probably noticing two foundations that may be new under this category, and that is because of generative AI, right? In the past, we would not have included drafting contracts and agreements or drafting pleadings and motions underneath this artificial intelligence category. But now we do have generative AI, and so we are, this particular foundations are now going to be included within this set. And so we do have foundations of 39 courses as well as 25 courses. This is also where I want to remind you that this data set is from 2023. And so generative AI was probably not as popular within technology courses at that point. We do have a data set that we have not gone through and crunched yet. I'm betting these numbers will be very different when we start going through this new data set. So, look in the future for new data. I'm sure that these course numbers will be much higher the next time around. One other thing on this slide that I want to highlight, if we go over to the examples of practical application, we did want to share some additional information about large language models from one of our other sets of data that we have. When we were looking at large language models and for-credit courses versus informal courses being taught and doctrinal courses being taught, we found that large language models is being taught in for-credit tech courses 53% of the time, in informal courses 28% of the time, and in doctrinal courses at 13% of the time. And again, this data is from 2023. When we look at data security, which again is another really hot topic, even in 2023, very important. And again, I think that once we crunch our data, our most current data set, I think we'll see these numbers even higher than what they are, even though we've got, some pretty high numbers from our 310. Keeping information confidential, we're seeing 215 courses. Exhibiting flexibility, adaptability regarding unforeseen and ambiguous changes in circumstances. We're seeing 265 courses. Being able to be resilient after a setback. So again, if you've got one of those data breaches, how do you address that? We have 83 courses addressing that particular topic from a technology point of view, and then making decisions and deliver results under pressure. In the practical applications, from a technology point of view, we're looking at cybersecurity, data privacy, compliance, encryption, VPNs, passwords, and disaster recovery, and business continuity plans. Now let's move over to soft skills that are incredibly important, right? We know how important communication is. Communication between team members, communication with clients, both in written format as well as electronic format. And yes, even these soft skills are going to require a technology arm as well, and we're including it within our tech courses. And so off to the side in that box, you're going to see some of the examples. Again, this is not an exhaustive list of the technology components that are being taught within these courses, but we're thinking about things like video conferencing, like Zoom and WebEx, thinking about emailing or messaging apps, websites, intranet options, things like that that are going to aid in communication and collaboration. When we look at our course breakdown, again, I always am very interested in not just which foundations have the most courses attached with them, but also the ones that have the least courses attached with them. One of the things that I thought was really interesting is if we look at this, speak and write in a manner that meets legal standards. And what we see here, we have 38 courses, but that in contrast to speak and write in a manner that meets professional standards, and that is at 145 courses. And so for me, when I look and compare those two things with courses, it really makes me wonder if that is because of some of those ABA standards we talked about in the very beginning, where we now are looking at, there is now that standard about having graduating students that that are at a level of professionalism, and it are when they're doing their writing, are we now trying to push this legal standard versus having a professionalism standard when they're graduating, and whether or not that might be a learning outcome or a learning objective for some schools across the entire academic or across the entire school. So I don't know. It's just sort of something I was wondering about when I was looking at those data points.
So to recap, we covered how law librarians are offering technology instruction. We also see how tech skills are embedded in the curriculum. And now let's look at how law librarians have taken the lead on technology innovations. So I'm going to give you a minute to take a look at these law librarian-led innovations. And this isn't an exhaustive list by any means, because we've all heard from wonderful presentations throughout this conference, and we know of someone who's trying to break through in their own institution. This list features some key law librarian leaders, and these case studies demonstrate the evolving role of law librarians as leaders in technology innovation within legal education. You can see that there's a clear upward trend in the number of technology-driven initiatives led by law librarians over the past few years, and this chart highlights their proactive efforts to integrate digital tools and resources into the curriculum. Librarians are not only offering technology instruction and embedding tech skills in coursework, but they're also at the forefront of adopting and implementing emerging technologies by facilitating access to advanced research platforms, integrating AI tools, and introducing digital literacy programs. Law librarians are shaping the future of legal education and ensuring that both students and faculty remain equipped for the rapidly changing legal landscape. I know that some of these leaders are presenting and attending Cali this week, so I would encourage you to chat with them about their work, either in person or virtually. As the last slide demonstrated, many of those initiatives were not done by law librarians alone. Effective collaboration among librarians, IT professionals, and faculty was essential to maximize the unique strengths each group brings to the table. So this would mean law librarians can lead technology training, design curriculum, provide research and instructional support, and foster that digital literacy. For law IT professionals, that would mean implementing and supporting technology infrastructure, ensuring the security, making sure things are sustainable, and enabling access to digital tools. For law faculty, that's integrating technology into doctrinal and clinical teaching and giving us the access to do so. Collaborating with librarians and IT to design tech-enhanced assignments and assessments. And effective technology education requires close collaboration between all of these groups, with law librarians often serving as the bridge. Now, let's talk about how we can implement this. The best way that we recommend doing this is incorporating these strategies into the curriculum. And because we know that is not readily possible or even available at most institutions, let's break it up into pieces. For law librarians, it can mean offering credit-bearing courses or informal workshops on legal technology, research tools, and practical applications, basically continuing what we've been doing. Providing ongoing faculty development and support for instructional technologies. If you have the capacity to, lead or participate in curriculum committees to ensure technology is embedded throughout the program. Delivering synchronous and asynchronous tech training via webinars, tutorials, and virtual office hours at a variety of different venues such as Cali, AALS, or AALL, or even within your institution. And then using interactive tools, polls, breakout rooms, and collaborative documents to engage remote learners.
So in the case of law faculty, if you have the opportunity to or the ability to, what you should be doing is actively partnering and collaborating with librarians to find opportunities to embed technology modules into doctrinal courses or clinical courses. So this could be done by, finding out what is already available. Maybe your school has something like an NSLT program or a Procertus. And so if you're teaching an e-discovery course, or you even have a traditional criminal law course, and just have them do an e-discovery portion of one of those programs as a homework assignment. That could be something that gives them a little bit more technology instruction keyed to a more traditional doctrinal type course. You could assign tech enhanced projects, or potentially have a virtual simulation. So, I know I've talked with some of our faculty here that if they're working on a project outside of, just those standard projects, and I don't know about your institution, but a lot of our times at our school, they'll be given a spring break project for some of the courses. And I said, why can't they just have some technology element to it? And have them, just give it a couple of points, right, for this one technology component as well. So sometimes just assigning a little bit, maybe just a couple of points for some type of technology element to it. Or I do know with one of our professors, they actually allowed the students to, instead of just doing a written assignment, they could do a video or a song. So then it forced them to go beyond just the traditional Word, working with Word. They were able to use some other technology components for a project. Or it may be something as simple as faculty inviting librarians to join the curriculum committee. And by that, they're able to ensure that technology is being embedded throughout the program, because that's another voice at the table that's able to have those communications and talk about what's available to them, be it if it's I could guest lecture in the course, or here's the technology research opportunities that's available. Here are databases that could support that particular course. So being able to add to that conversation. And then finally, you have the opportunity to actually have technology rubrics, which is something that Jessica and I are working on a paper on this topic as well, where you could have a set rubric to add either across the entire curriculum, or even based on courses, where you have set technology elements within that course, or across the entire curriculum, to ensure consistent and measurable outcomes of technology. So that way that there are at least some key technology components that your student population are receiving.
Now we know that innovation can't happen without law school administration buy-in. So law school administration must recognize and support law librarians as technology educators and curriculum designers. Even within these times with budget constraints and et cetera, et cetera, et cetera. They should financially support joint pilot projects, vendor partnerships, and innovation labs to keep curricula current. I know that for many institutions out there, there is more of a focus to focus on AI and these new emerging technologies. And so a lot of that can't actually be done without the money or the financial support to do so. Law school administration should not only require rubrics, but they should also require rubrics that define and assess technology competence across the courses. And I'm going to speak as very selfishly and from a very biased perspective as the chair of my school's learning assessment committee. Maybe law school administration should support and develop a law school-wide learning outcome specifically tied to technology competency. We're required to regularly assess what our learning outcomes are. And as we need to be able to add, subtract, modify learning outcomes that are not only known within our school, but also publicly available and known to the rest of the world. And so technology competency, we know it's here, and we should create a law school-wide learning outcome specifically tied to it.
So we have talked quite a bit about what is currently being offered through the ABA, through ABA-accredited institutions, how law librarians are kind of taking the lead on that. But for those of you who are not already doing so, I have a call to action for all of you, because the reality is that if you can't do it on your own, go out there, become collaborative, because the reality is that for us to truly have the future ready curriculum, it does have to have that technology component so that we are meeting those ABA standards, not just the ABA standards for legal education, but also to ensure that that when we graduate those students, that they are able to meet their professional standards as well under 1.1 and Comment 8.
That's it for our presentation. Thank you so much for listening to our talk, and we will address any questions that you have at this time. Thank you.
Okay. I think they can hear us. Can you hear us?
Yes.
Excellent. First of all, there are a couple of online questions. You should be able to see the Q&A at the bottom of your Zoom
Awesome.
thing.
Open that up.
Open those up.
Sweet.
I will get them. Yeah, we can get them on the screen here too.
Okay.
Can you see it? There we go.
Jess, do you want me to read them?
Yeah, you can start with those, and then we'll.
Okay.
Yeah.
There's just a couple there.
All right. So, do you want me to read names or no, Elmer?
Oh, we can see the names. So.
Oh, perfect. You got them up there. Okay.
On the thing so that the QR codes are visible.
Oh, I'm sorry.
All right. So, has the growth in tech teaching meant depersonalization in legal research or other practical skills teaching, or is it an expanded part of the law school curriculum? So I can tell you when we're doing our data searching, we are not looking at legal research courses. So we haven't done that work. I would encourage someone that's another paper out there for somebody else. Our work, what we're focused more on is legal technology, and technology related courses, and that's sort of our space. But I think that's a really interesting thing. I can tell you just personally at my school, what the way we've done it is we teach it differently. So legal technology is offered once every year, and it's offered during the summer. So that way we ensure that it is always offered. And then during the school year is when the legal research courses are offered. So that way we're always doing both. And that would focus on the for credit. That doesn't take away, I think, from the informal. I think that many schools are still doing both the informal research instruction, even if their formal has gone to focusing on the technology. But I can tell you, I don't have the data to support that. That is just completely my own personal, what I'm seeing. Jessica, what are your thoughts?
Yeah, I was going to go and say, to echo Katie's sentiments, that our data set doesn't include things like advanced legal research, or even when law librarians go and teach in 1L courses, only because from a collection perspective, I think anecdotally, and there's lots of other literature that already demonstrate that we're already in those courses teaching the technology. Our focus was much more along the lines of what else are we doing outside of what we're either expected to do or still fighting to do. So at our school here at UConn, I have law librarians that will teach advanced legal research. We also have other specialized legal research courses that I know that at some other schools they don't have them. So we'll have like a foreign and international law one. We will have one that is specifically geared towards research and social justice. And we also have law librarians that are teaching, but are not the professors of record at the 1L level. And so I don't think that there's a diminution in legal research or other practical skills teaching. I do think, though, that law librarians are able now, or are better adept at trying to get themselves inserted in other areas of the curriculum. And that's also part of what we tried to capture in this new article that we have coming out hopefully soon with Jolt. So to answer that question, yeah, I think that technology is an expanding part of the law curriculum. I think over the next few years, and as generative AI and AI generally like blows up, and I think that we can go and see how many law schools are actually going to start teaching in artificial intelligence. I mean, in our past scholarship, we've seen when there was a big trend for e-discovery, we saw that a lot of schools, just 80% of schools, 90% of schools, at the time that we had collected that information, were starting to teach e-discovery. We know that technology has been important because we have IP courses. So we'll wait to see in this 2025 data set that we have whether or not law schools are continuing to carry that trend. Yeah. Do you want to address the next question, Katie?
Yeah, next question. How do you characterize the difference between communication to meet a professional standard versus a legal standard? So when we had our students actually gathering this data, one of the things that we did was because we've learned through many different sets of research assistants how to set up spreadsheets. And so we actually keyed in the foundation themselves. So we gave some examples of sort of what we were looking for. I know with the communication standard, one of the things was actually what they were writing, because it was communication of writing and speaking. And so it was actually what that work product was. That was kind of the outcome. So if it talked about the writing or communication via email, was kind of more that professional standard versus, writing or communicating for, say, a deposition or for a memo or a brief, then that's where it was more for that that legal standard.
Yeah.
So that was kind of how we broke those two up, was looking more at what that final work product was for the communication.
Yeah, it's very work product dependent. So if the syllabus or the course description was very descriptive as to what the output was, then we would link that particular foundation to that work product. And that's how they came about it.
Don't. Sorry, y'all. Some of these, I love all the questions, but some of them are jumping as I was just about to read it. Okay. Do you have concerns that Procertus and Wickard will lead law schools to outsource legal tech education? No, because I think it is used as well, I will put this out there as this is my personal opinion. So my personal opinion is no, because you asked for it. And the reason why I'm going to say that is it is all up to the instructor and what the instructor is willing to put in. So yes, potentially at some schools, this could happen. But I think that's a lazy instructor. Because if you just decide, I'm just going to give it to a product, be it whatever product it is, then, and I'm not saying that if it's better than nothing. And all tools are very different. So schools have to evaluate the tools that best meet their needs. So that is, I put all the things out there. But I do think that if we're thinking about this from a course point of view, that an instructor most of the time are using it as a supplement to build upon. A lot of times I use it either as a homework assignment after I've provided instruction, or I use it as a foundational base, and then I do instruction on top of it. So that's why I don't think that it will be outsourced. But then again, what a school chooses to do, I mean, that's going to be an administration decision. And I do think some tech instruction is better than no tech instruction.
So I was going to go and approach it from an administrative perspective. So I know that Procertus and Wickard, and I mean, let's even say for like bar prep, right? I know that that wasn't particularly mentioned in this question, but a lot of law schools are now looking at outsourcing their bar prep, right? So we're looking at vendors like Access Lax, right? Who are offering those kinds of things. And the reality, I think, is that as law schools are looking at what resources they have on hand, there's a recognition that between retirements, attrition, just skill sets, right? And the ability to do so, just sheer number of people who have the skills, and how you want to tap those resources, it sometimes makes more financial sense for a law school to go and outsource it. And that's where I will agree and echo Katie's sentiments that, there's some instruction by someone is better than nothing. But I think that as law librarians, because we interact with Joe from Procertus or, Wickard or, whoever the vendor
Doug from
is out there.
NSLP,
Right,
right?
right. Like whoever that vendor is, chances are they're usually using us as a conduit, right? They're usually talking to us about, hey, how else can we get into these courses? How else can we get into this? And I think that we're probably much more in the room where it happens, or in the know, much more than what they are telling or what they're saying to our academic deans or et cetera, et cetera. And so I think that we can be kind of like that checks and balances, right? Like we can be that person who, or that, that influencer, right? Who can go and say, yes, the money is worth it, or no, the money is not worth it. Because as Katie pointed out, when you take that and then drill it down into the course level, especially if we are instructing in our own courses or we have supervisors or colleagues, allies that are teaching those courses that are infusing these products and we ask for that feedback, we are in a position to go and say, yes, it's helpful, no, it's helpful. So I think that they could help law schools, bring about that tech education, but I don't think that they're the end all be all, and I don't think that they're necessarily going to lead it.
And I'm going to actually tag the off of that and bring us into the next question, because I think what a little bit more of the end of that question, and then it ties into this. So we have, what sort of things have you seen motivate administrators to take this type of competency training seriously? And then have you made inroads by highlighting anything specific? So what you were kind of talking about towards the end of your answer about partnering, I think is very important. And I think is another way to get buy-in from administrators. I think it's really important to find opportunities, especially if you're at a school where you struggle. If you're interested in technology and you're having trouble getting other folks to get excited about it. And I know that that happens in some schools, right? And like you feel like you're an island in yourself. Finding opportunities to partner even with other departments. So say maybe for whatever reason you can't get buy-in from other faculty members, does your career services department have an opportunity for partnering, right? Do they do a series before OCIs where it's the like, let's do some trainings on doing proper research before you go into the room for OCIs? Like, how can we do that type of tie-in? Does your career services run a professionalism series? And can you then tie into maybe one of these technology programs to say, as a true professional, you have to know technology. So maybe we can, get one of these certificate programs tied to it. Are there things that you can do where you could partner with another department and make it potentially have even more value and get other departments excited about it as well? Because there's strength in numbers if you have trouble getting that buy-in on your own. So I've seen that to be really valuable. Something else too, if you get law firms in your area excited. So one of the things that I know that I've had success doing, I know Jessica's had success with this, is getting and speaking at local CLEs and being invited to speak at law firms in the area. that gets your deans really excited. And then they like to go to events, and then people will be like, oh, I saw the dean of the library talk about blah, 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 blah. And then you start like locally, people will want to compare notes on the big thing I'm being asked to talk about is generative AI right now. And so that's something that they get excited about. And then you get a little bit more gravitas, and then you get a table, you get a city at the table, and then that's another way to get some more buy-in.
So this specific question that was asked, I don't know, so it says, what sort of things have you seen motivate administrators to
Yeah.
taking this type of competency training seriously, and have you made inroads by highlighting anything specific? So what I can say here at UConn is that, well, my personal take is that I will always encourage that if you earn the flowers, you should keep the flowers. And so when we have students, especially graduating students, who come back and they say publicly on social media to the dean, directly to anybody, and they're just like, you know who was really helpful? The library. You know who taught me that tech skill? The library. You know who taught me those research skills that's going to help me in practice? Because when I went to my summer job, the lawyers were so impressed that I knew this. You know how I knew that? The library. And so when our deans hear that the library time and time again comes to deliver, and then we have alum. And so we have alum that will then repeat to deans and say, you know what's really important? We find that, we reinforce at our firm that we need tech skills. You know what's really important? Tech competency skills. You know what's really important? This. And then, especially if they know that there's someone or a group of people at their institution, particularly from the library, who are talking about these things and reinforcing these, then our deans get motivated, right? They can now go and engage in these alumni conversations where alumni are interested to be engaged back at their school, where they're interested in what's this new initiative, that you're doing at the school? Can I give money to that? I don't know. Money talks. So, I think that that's a really good way for administrators to see that competency training is really taken seriously, because if they see that they're alum and that there's other people basically in positions of power that are within their sphere that are re-emphasizing it to them, it only echoes, what we've been trying to teach for so many years.
Does anybody in the room have questions? Oh, I see a hand. So we'll take, Doug, go ahead. I
Hi,
think they can hear
Jamie
you.
and Jessica, it's Doug from the NSLP.
Hi.
So, first comment is, have you thought about expanding your data set to include ABA-Accredited paralegal programs, where this has been a topic that's a required course for 15 years now? And so you've got hundreds of schools that have been for 15 years at a place where you're trying to get to. And so, do you look at those, and if not, then why try and reinvent the wheel to do something that they've already done and been?
So we have not. And why we are not is because we're trying to get them in law schools. Because I can tell you many of our administrations, I can tell you from many schools that I have been to, I can think of most of my deans would say, I'm not going to look at what a paralegal program is doing. And it's just what they would say.
Right, but is that just because of I get it in other topics, but paralegals, the reason they've been hired for so many years is what their tech ability is. That's the number 2 reason they're hired for their job. And so where we're trying to teach lawyers, in essence, really how to do paralegal work when it comes to tech, which is really what it is. I know we hate to have it sound like that, but that's what we're doing. And so why not go to the people who have been the experts in that topic to develop the courses and develop what that looks like? Why ignore that much? Well, I'm not saying ignore, but why not model after what they have been through? I teach office technology. I've taught it 72 times. And so I know what I'm talking about in the topic, And, it's, listening to the conversations on this, these are answers we have to the questions. But yes, paralegals were listening to them because they're the ones who needed them first. And so why the reinvention, I guess, is it just because we don't want to take an idea from a paralegal program? We see them as a lesser program? I mean, why the hesitance and the pushback in the industry to follow something that's already been worked out, I guess?
So I think one thing and I'll let you go in a second, but one thing I want to point out is we're not talking about developing courses. What we're doing is we're identifying what is already being taught. So like our data set is what is out there currently. So that's just one thing that I want to clear up. And again, I'm not in the room, so there may not be a miscommunication, but I wanted to make sure because you did say, why aren't we developing the courses? We're not suggesting developing courses. What we're talking about, at least with our data set, what we're looking at is what is already currently being offered to identify what weaknesses are present. So I did want to say that. And Jessica, go ahead.
Yeah, no, I was also going to go and say, like, I think that looking at paralegal programs would be an interesting comparison, but I think that one of the things that we would have to do when doing that comparison is seeing how, and I personally haven't looked at it, so I can't speak to this. I would wonder what the compliance standards are for paralegal programs versus ABA-accredited law schools, because I think that, and this is just human nature, it's just not, and I'm just pontificating, that
They
we
follow
only do the things that we're expected to be compliant for. So if we're not, I don't know if law schools, I don't know if it's, well, let me say it this way. I don't know if it's right for me to say that law schools think that paralegal programs are a lesser program, but I do think that it's, I think that it's interesting, but as we develop as law schools try and figure out, do we need courses and should we have those courses? I should also point out that in our data set, I want to say 56 law schools were identified in our data set as either having no tech course listed, which could mean a variety of different things. It could mean that there really was no tech course listed, or that there's just simply no tech course, or it was behind a paywall and we can't get access to it. And so I would, in addition to probably looking at like paralegal programs, I would also just wonder, like, why aren't these schools on the bandwagon, right? Like, why are we still fighting this like tech competency? And then I think that that's where our scholarship, it's obviously evolved over the past, few years, but it still feels like we're like knocking on that door of like, why aren't you including tech competency? And this article really, was kind of like when we looked at all of our data, we're just like, wait a minute, like we should totally write an article about how law librarians are shaping what technology competency is today, because that's what our data set shows. But yeah, looking at paralegal programs, I'd be interested in seeing what the compliance standards would be for that.
So actually what I'm thinking right now, to just jump in, because if it is an ABA accredited paralegal program, they probably have the same standard as us. And I'm wondering, and what I would want to look at is whether or not, just like how with LLM programs, sometimes they have like people who are taking the LLM are actually in the same class as people who are JD candidates. So I'm wondering if people who are in the paralegal program, if there are people who are in the JD program who could also sign up for the same class, and if it is the same tech class being offered. That's what I would want to look at those schools. I'm interested in finding out that. Like, that's just sort of a general, like, I think you've given us something we want to look at.
Well, there are a lot of schools that do that have the paralegal programs housed under the law school, and the students co-mix into those courses.
Yeah, so I'm wondering if we're already tracking those courses, and if it is in our data set, but we're just tracking it as a JD candidate course because it's one where it's sort of listed under both.
What I think you'd find interesting is is comparing the two, where each one is, by looking at a data set of paralegal versus a data set of law schools. And comparing the two to each other. Would be very interesting to know.
And
Well, especially because I know at my school, we graduate a lot of solo and smalls, which is why I started getting interested in this topic in the first place. In 2017, part of the reason why I started doing this research was because we did a survey of externship sites and a lot of our placement sites, and they were all saying, hey, none of them know how to bill. None, like we were getting feedback that they didn't understand technology. And so that's why I started teaching it in the very beginning, was because of that. There was this need. And that was just because, again, we have a lot of folks who go to small, so they're their own tech, right? They don't have a lot of paralegals. They have to know how to do it. And so I'm sure that there are a lot of schools that may be in the same boat. And so they don't necessarily have the paralegals that have that additional training to do it. So I think that may also be why we're seeing more of a need for technology training at law schools that just across the board.
I know that we're over time,
Oh,
but I
yeah.
also
All right.
wanted to mention that there's a question that can easily be answered in the chat, which is, where can you point us towards which article has the mappings of lawyer competencies and et cetera, et cetera. So what I'm going to do is that I'm going to just tell everyone briefly what the 3 QR codes are. So the first QR code should be, I moved my computer. It should be to our Georgetown article, which the Georgetown Journal of Legal Ethics article starts us with, you'll get the history of why we started doing this longitudinal study in the first place. And we are starting to collect our course data then. Then we have our University of St. Thomas article, which basically continues our longitudinal study, but instead focuses on law firm job descriptions and compares those to the whole lawyer model. And we're doing that comparison of competencies and capabilities, really bringing out more of that whole lawyer model as is this job description, or are these firms really asking for what they're asking for, and which the answer is no. And then the last QR code is the upcoming JOLT article. So all of those 3 QR codes are leading to SSRN pages where you can go and download those articles. So I hope that answers the question there.
all right, thank you.